Hi Cyber Law class, it's Professor Opterbeck and welcome to this week's virtual class. This week we're going to talk about search and seizure law and self-incrimination law under the U.S. Constitution and the Bill of Rights and how that applies or potentially applies to cyberspace. So we're going to talk first about search and seizure law in the U.S. And the portion of the Bill of Rights that governs this in the United States is the Fourth Amendment. So we see the text of the Fourth Amendment here. And of course, the Fourth Amendment does not ban all government searches and seizures. It recognizes that in order to perform its law enforcement functions, its police powers, state governments and the federal government are going to need the power to conduct searches and seizures. But the core principle of it is against unreasonable searches and seizures. And if you recall from some of our discussion about the development of the Bill of Rights, one of the big complaints that the American colonists had against the British was that the British law allowed in the colonies these issuance of general warrants, and the general warrants were not specific to any particular allegation of a crime, and they weren't specific to the place or the thing to be searched and seized, and it really gave the British authorities kind of almost a blank check to enter into someone's home or premises or business and to conduct a search or to take things. And further, the British often used the military to accomplish this. So part of the background of the Fourth Amendment is this reaction to this British practice. Now, of course, this also was a deep principle even in British law. It went all the way back to the Magna Carta. So the practice in the colonies of sort of general warrants or general writs was really a practice that wasn't even consistent with the broad principles of British law. So it's a very deep concept that the power of the state is really brought to bear in this area, as we've discussed, of criminal enforcement, and this is one of the ways in which it's really brought to bear. In order to investigate crimes and to implement the police power authorities that the state has, the state can use these search and seizure powers. So it's very important that we have these legal principles that limit and put boundaries around what the state is able to do. So, basic idea, unreasonable searches and seizures. What is unreasonable? Well, that's a question that the Supreme Court has developed in lots of case law over many years. And it's not entirely defined, and nor should it be, because reasonableness is kind of one of those principles in Anglo-American common law that is meant to be sort of broad and to be fleshed out by the courts. And we'll see in a few moments when we look at the Carpenter case how the U.S. Supreme Court is beginning to look at this in the new digital era. But there are some other specific things in the Fourth Amendment, and in particular the Fourth Amendment deals with this question of warrants. And when we're talking about a warrant, what that means is it's a form of order issued by a governing authority, issued most often by a court. And a court is giving permission for the authorities to conduct a search or seizure. And the question for warrants then is, when can a court be authorized to respond to a request by the government to conduct a search or seizure? And the core thing here is this idea of probable cause. And you've probably heard this term probable cause, and if you haven't studied this area of the law at all before, you've probably heard it on maybe a police procedural TV show or in some other kind of discourse. So probable cause, and I'll talk about in a moment what that means, supported by an oath or affirmation, particularly describing the place to be searched and the person or things to be searched. All right, probable cause. In general, in American law, this means that there is probable cause to believe that a crime has been committed or is about to be committed. Now again, that standard isn't entirely fleshed out, either in the Constitution or in that general formulation that I just gave you, but the cases flesh it out. So there has to be some, specific reason that the authorities have to believe that there has been a crime committed. Remember our principles of criminalization, and crimes are things that are on the books defined as crimes, or a crime is about to be committed. Supported by oath or affirmation means that the officer going to the court, asking for the search warrant, has to submit an affidavit or a similar form in which the officer swears under or affirms under penalty of perjury that what is said is true or correct. And the principle behind this, as the principle behind all other sworn court testimony, is that it helps ensure the truthfulness of the testimony, at least theoretically. And it does that by having this potential punishment of being found guilty of perjury. And perjury ultimately is a crime. So the intentional swearing of a false affidavit is or should be at least a very serious thing. Now sometimes this means actual testimony in court, but more often with a search warrant, it's a written oath or affirmation that has that same force. And particularly describing, and this is going to be something we'll talk about in the Carpenter case in a moment, means that the warrant has to include at least some degree of detail about what the reason is for the search or seizure, and the location of the search, and the items to be seized. So it can't be just a general warrant saying, against Joe Smith, we want to be able to search and seize everything related to Joe Smith. That would be too broad. It has to have some degree of specificity, and that specificity then is connected to the probable cause that a crime has been committed or is about to be committed, and is supported by that oath or affirmation. So there is a real burden placed on the government when it is swearing out a search warrant and on a court to look at this. Now, it doesn't mean that it's incredibly difficult for the government to get a search warrant. It doesn't mean that judges are, in every case, very carefully scrutinizing these things. In fact, in most ordinary law enforcement, this is a relatively routine process. Very few search warrants are rejected on their face. Very few are subject to any great scrutiny up front. But it is at least an initial burden for the government to obtain the warrant. It also comes into play later on if in fact someone is charged with a crime. Because if the defendant who is charged with a crime claims that a search warrant was improvidently issued, that the probable cause that was sworn out in the warrant really wasn't adequate, and or the warrant really wasn't specific enough, then the defendant can file a motion to suppress the evidence obtained from the warrant. And then there's another doctrine called the fruit of the poisonous tree, which says that the evidence obtained from the improvidently granted warrant, and then evidence obtained from that evidence might also be excluded. So that really, in most cases, there is this initial hurdle the government has to go through, but in most cases the actual enforcement of the problem is if there is an indictment and the defendant then moves to suppress the evidence. Now notice this, because the general principle is unreasonable searches and seizures, that it's not the case that in every circumstance where the government wants to search or seize evidence, there has to be a search warrant. The search warrant in American constitutional law relating to search and seizure is sort of the gold standard. If you get the search warrant and it's properly supported, the government is on very solid constitutional grounds. Now, if you don't have a warrant, if you have a circumstance that maybe is an emergency, an exigent circumstance, and there's a danger of the suspect fleeing and the evidence dissipating, right? Those are circumstances on which a search and seizure might be conducted without a warrant. And there are plenty of instances, many instances, in which that happens, and there's case law to describe the general circumstances on when that can happen. For example, as I described, the suspect is fleeing, the evidence might be destroyed or dissipated, but the government is on more difficult ground. So, if you are an investigator, if you are a district attorney, to the extent you can, you want to support gathering evidence through a warrant. But we'll see in the context of electronic evidence, there's a bunch of other doctrines and a bunch of other rules that really complicate this. So the first one we'll look at is the third-party doctrine. What the third-party doctrine says is that there is no legitimate expectation of privacy in information a person voluntarily turns over to third parties. So notice this language of expectation of privacy. When we're talking about what a reasonable search and seizure or unreasonable search and seizure is, that is tied to this concept that all of us have some kind of reasonable expectation of privacy in certain aspects of our person, of our property, our personal effects, and of the locations where we are, in particular in our homes, but also to some extent in the places where we work. And this is an expectation of privacy in relation to the government. And so the question here is, well, what if you give information to a third party? So let's say Abel, A, right, has a document. Here's our document. And this document that Abel has some information in it that may be of interest to the government with respect to some potential crime that the government believes Abel may have committed or might be involved in. So the government wants to, here's the government, G, right? The government wants to get this information from Abel, and if it's going to get that information from Abel, then it has to be a reasonable search and seizure. It could be under one of those exceptions to the warrant requirement, or the government might get a search warrant and get the information from Abel, and that's often what the government does. Of course, once the government does that, Abel knows that the government is looking at Abel and looking at Abel's information, and that gives Abel an opportunity legitimately to obtain counsel, and perhaps illegitimately to alter or destroy evidence. So there's many circumstances in which maybe the government doesn't initially want to go to Abel and either without a warrant or with a warrant search Abel. So, but let's say that Abel has transmitted this document to Barry, to B. And maybe Abel has sent it by email, or maybe Abel has physically given the document to Barry. Now, and let's say the government has reason to believe or has some knowledge that Barry has the document. Well, the government can get the document from Barry. Now, it could be that the government, that Barry is not cooperative and that the government needs to get a search warrant or otherwise engage in a reasonable search under the Fourth Amendment of Barry and obtain the document. But maybe Barry is cooperative with the government. Maybe Barry is voluntarily willing to turn the document over to the government, and that could be for lots of different reasons. It could be that Barry is not involved at all in any aspect of crime and is just simply willing to cooperate. It could be that Barry might be implicated as well, and the government might be making a deal with Barry to either not prosecute or to reduce the possible sentence if Barry is convicted. There could be lots and lots of reasons why Barry might be willing to cooperate. So here, the actual document originates with Abel, and Barry is really a third party concerning this particular document that originates with Abel. And the third party doctrine says, once Abel lets it go, once it gets out of Abel's control and goes to Barry, Abel has lost whatever expectation of privacy Abel may have had in that document or in that information. You know, it could be Abel talks to Barry and there's spoken information. Whatever it is, Abel has given up that right of privacy. And that would be the case even if there's some kind of agreement between Abel and Barry. So now, without any search warrant at all, the government can obtain this information from Barry, and Abel has no constitutional recourse, no ability to complain that the information gotten from Barry somehow violated Abel's constitutional rights. I'm just going to erase my ink here for a minute. And again, as I said, this presumption applies even if Abel and Barry had some kind of agreement that the information would only be used for a limited purpose, maybe some kind of agreement that the information wouldn't be disclosed, or really relevant to our context. Maybe, and I'm just going to put Abel and Barry up here again, you know, maybe Barry is actually Barry Corp, and Abel is a customer of Barry Corp, and maybe the information that the government wants is information that Abel is giving to Barry Corp in the ordinary course of whatever business Barry Corp is doing for Abel. And this is a very common scenario. And in our context of cyber and of electronic information, you know, think about how broad this could be. So who could Barry Corp be? Well, it could be, let's say, Verizon, your telephone provider. So I've got my phone here, and we've mentioned this once or twice in class already. Right? This is an incredibly powerful computer that we have in the palm of our hand. This computer, this device, in its cellular communication, is constantly pinging nearby cell towers, and that's how this thing works. That's how the cellular capacity, the calling and texting capacity of this device works. It's telling the nearby cell tower, I'm here, I'm awake, I'm available. And then, so if someone else is, you know, sending me a text or calling me, it's communicating in that way. All of those pings to that cell tower are pinging to a tower that is controlled or leased, available to Verizon, my cellular provider. And all of that information, all of those pings to that cellular tower are in the possession of Verizon. And those are all records of that relate to me, that in agreeing to the terms of service with Verizon for my cellular service, I've agreed that Verizon is going to collect and is going to maintain. So if the government is seeking from Verizon the information about the location of my phone based on those cell phone pings, the third-party doctrine, traditionally understood, would say, I have no expectation in privacy about that, even though it's a lot of data. Now, we'll look at the Carpenter case in just a moment. We'll see that's a place where the application of the third-party doctrine has been tweaked by the Supreme Court. But this is the kind of issue that arises in our digital context. Let's take another one. We'll take, let's say, Google. So this is a Google phone. I use Verizon as my cell carrier, but I use Gmail as one of my email providers, and I use Google Drive as the cloud provider for my personal stuff and for some of my professional stuff for cloud storage. So there are, you know, terabytes of information of mine that are stored by Google, right, in the cloud on servers that Google controls and owns under a contract that I have with Google about that information, and that includes emails and that includes other kinds of documents. So let's say the government, you know, is investigating me. It wants to hold off on serving any search warrants on me yet. It doesn't want to tip me off about the investigation. It can serve process on Verizon, it can serve process on Google, or it can simply talk to Verizon and talk to Google under the third-party doctrine and get that information without any kind of process at all. That's what the third-party doctrine says. Now, we're going to go in just a minute and talk about some ways in which Congress has altered that a little bit, and talk in some ways about how the Supreme Court has altered that a little bit. All right, I'm going to erase this ink for a second again. Now, let's say that there is information in transit. So again, let's say we have Abel, and let's say Abel is communicating with Baker, and Abel is doing that. I'm going to try and very badly draw a telephone. Abel is... That telephone doesn't work. Now, let's talk a little bit about information in transit. So let's say Abel is communicating with Baker and is doing that over a telephone line. I can't draw a telephone, so let's assume this is I'll just sort of put T for telephone. So that's a telephone. Now, let's assume this is traditional landline service, which is where the doctrines we're going to talk about first grew up. And in traditional landline service, the government wants to hear what Abel is saying to Baker in real time. So in traditional landline service, the government actually puts a line on the wire somewhere on one of the poles, splits off the physical line, into the proverbial government van, FBI van, sitting in the corner with the agents listening on their headphones and the reel-to-reel tape recording the conversation, and that is called a wiretap. Under the third-party doctrine, that would be perfectly fine. I am letting the information go. I'm letting the conversation go. I don't have, traditionally under the third-party doctrine, a reasonable expectation of privacy in my communications with Baker. Now we'll see, Congress has modified this really significantly in the wiretap statute, but in the constitutional doctrine, the third-party doctrine would apply. And now, of course, in the more modern context, many of us aren't using landlines anymore. We're having those communications over cellular networks. So a wiretap isn't literally a wiretap anymore, but it would be a kind of electronic interception of those communications in transit. And again, the third-party doctrine would not prohibit that in itself. We could also say maybe this is an email. Can the government intercept an email in transit? And the answer would be, under the third-party doctrine, yes, they could. But again, the Wiretap Act is going to change this. Now, of course, in the analog telephone context, it was and is much easier for the government to execute, to technologically execute a wiretap. You simply have to tap the line, and with analog communications, you don't have to deal with encryption. Now, of course, with digital communications, with cellular communications and email, the government very well may have to deal with encryption, and that's another question. And some of that question for communications in transit is what we were talking about last week. And my paper, which I've asked you to look at again for this week, on the general idea of encryption and information in transit, deals with that question. Okay. So given that we have the third-party doctrine, in the analog telecommunications era, before digital and before cellular, Congress had already stepped in and decided that, well, the third-party doctrine applied to wiretaps, we don't really like the way that relates to what we think ought to be the degree of privacy that we might have in our telephone communications. And Congress therefore passed the Wiretap Act. Now there's a few different statutes and things we're going to look at here. I didn't ask you to read all the statutes because they are, on their own kind of long and ponderous, but I'm going to give you some explanation of them. So the Wiretap statute applies to the content of communications in transit, and that will include, traditional analog telephone service, but it is extended also to digital communications in transit. So that could be intercepting an email in transit. That could be intercepting cellular communications or text communications in transit, right, as they're crossing from my device to another device. And the standard in the Wiretap Act is actually stronger than the standard for a general search and seizure under the Fourth Amendment. The Wiretap Act requires what we call a super warrant. So the super warrant requires a showing of probable cause, the same probable cause, crime has been committed or is likely to be committed, plus normal investigative procedures have failed or likely will fail or are too dangerous. So the showing the government needs to make at the federal level and then also under related laws at the state level in order to obtain a wiretap or its digital equivalent is a very high showing. Doesn't mean, again, that the government is unable to make this showing, and it doesn't mean that wiretap order applications are routinely denied. They're not routinely denied by the courts, but it does mean that the government has to make more of a showing, and it does mean that evidence that is obtained through a wiretap is going to be subject to even greater challenge on the back end if the defendant alleges that the wiretap order was improvidently granted or that the information gained is the fruit of the poisonous tree. Now, in the internet era, as the internet era begins and the digital era begins, Congress realizes that it has to do something else with email and with other kinds of electronic communications. Because it's not exact, a lot of the information the government wants relating to email and other stored communications is not always information in transit. Sometimes it's information about the subscriber to the service that the provider has. Sometimes it's the actual content information that the government has concerning the subscriber. And Congress, in the Electronic Communication Privacy Act and part of that, which is the Stored Communications Act, has dealt with this. And we're going to look at this in a little more detail in just a moment, but keep in mind that this divides up identity and billing information and transaction logs from the actual content of the communication. So identity and billing records and transaction logs are very easy for the government to get. These can be obtained on something well short of a search warrant. And here Congress thought, right, the basic outlines of the third-party doctrine make sense. So I've subscribed with Verizon, I've subscribed with Google for certain services, and the fact that I am a subscriber, that this is my phone number, this is the IP address, this is my email account name, those sorts of things, the government can get very simply on a court order. Sorry about that. Just trying to find my my pen disappears sometimes. On a simple court order without any kind of notice to the other side. And that's very easy to get. Now, when we're dealing with content information, the actual content of my emails or texts or other things that have now been transmitted, but the provider has a record of them, it's going to get a little bit more complicated, and we'll see why and how on the next slide. And when we look at that, I'll also explain a little bit. You'll see the regime is a little bit odd, and I'll explain a little bit why it's that odd. We have another kind of order called a pen register and a trap and trace order. And this relates to information that is about the routing of a communication that is not the content of the communication. And the routing information here can be captured in real time. So notice that the pen register trap and trace is really a sort of, not really exception, but a modification of the wiretap regime. So the wiretap regime relates to the content of the communications. The pen register trap and trace relates to simply the routing information, still captured in real time. And this can be obtained on the basis of a simple court order, not a warrant, and the standard for obtaining it is very low. The information is relevant to an ongoing criminal investigation, and no notice to the subscriber has to be given. So that standard of relevance, very, very broad standard. The government does not have to show specific probable cause of any sort. Now, the pen register trap and trace and routing information is an interesting issue in the digital age. This, like the wiretap statute, was created in the analog telephone age. And the way that this used to work is, you had, I'm going to try and draw this, you have your telephone and wire, you have your telephone information going on a telephone pole, and then going, at the last mile into the house, right, and into the telephone, which is wired to the pole. So the equipment was created in such a way, and it was created in such a way partly as a requirement of the CALEA statute, which we have looked at, so that you could put a physical device into the box in which it's being routed. And that physical device, called a pen register, would tell you the numbers, the phone numbers, that were coming in and out of, or coming out of that specific line. You could also put a device at the junction coming into the phone or on the phone itself, if you were able to, get in there, and that device would show you the numbers coming out of the device. So you could get through these mechanical devices a record of all the phone numbers dialing in and all the phone numbers dialing out of a specific phone. Right? And why would you want to do that in an investigation? Well, that could be really important. You could have a cooperating witness, and you have the phone number that they are using, or you may have others that through warrants or other things you found the information and you know that they're involved in a criminal enterprise, and it gives you information that the person at this phone, using this phone, is communicating with other phone numbers attached with known suspects, and it bolsters, for example, the ability to get a wiretap order, because you might take this information and say, all right, we know that the communication is going in and out with this known criminal, and it supports a wiretap or a warrant or both. So there's lots of important reasons why the government might want to gather this kind of information. So the difficulty in the digital email age is it doesn't work like this, right? As we've seen from the beginning of the class, it works through packet switching. It's not one group of communication going over a wire, but it's lots of little packets that are going through various routes over the internet and that are eventually getting reassembled at the end. So how do you find non-content routing information? Well, it works through the way the email protocols work, the technological email protocols work. And if you looked at the source code, the source text of an email, you would see that there's a layer of code that contains routing information. What's the IP address the email is going to? What's the IP address the email has come from? time, date, other things like that. And then there are parts of the content that are content information. So effectively, what pen register trap and trace, the way it works in the the digital age and the email age, is that certain aspects of the header of an email can be looked at simply through the equivalent of a pen register trap and trace, while the content falls under the ECPA stored communications, or a wiretap, or search warrant, or other things. The last piece of this that I want to mention briefly are national security letters, or NSLs. These are interesting and were controversial, and still are, but especially became controversial after 9/11. So this is not involving a court at all. Notice all of these other forms of process that are alternatives to a search warrant, when we're dealing with things that could be protected by the third-party doctrine, involve a court looking at least some kind of order, even under a lower standard. And this idea that a court, that the judicial branch has a role to play, is considered a really important one in our conception of civil liberties and search and seizure law. But here with national security letters, it's simply a letter issued by the FBI without the court being involved at all, and it allows the kinds of subscriber information, toll and billing records, and transactional records that otherwise can be obtained through an ECPA order and or through the equivalent of a pen register trap and trace. And in this case, it has to be relevant to an authorized investigation regarding international terrorism or clandestine intelligence activities. And this idea of being relevant to international terrorism is what was particularly controversial in the post 9/11 era, because that concept was interpreted very, very broadly. Now, why would the FBI want to issue a national security letter instead of going and getting a specific court order? One of the reasons is that these national security letters were, especially in the post 9/11 era, worded very, very broadly. And they were very general and non-specific, and they were one avenue, in addition to the Foreign Intelligence Surveillance Act, or FISA, through which the government really was able to do a very broad-based kind of surveillance. The pen register trap and trace and the ECPA order for non-content information is not hard to get, but you do have to be more specific to a court. And here, the government did not have to be specific at all. So we mentioned the Stored Communications Act and the way it relates to email and the difference in the scheme for stored communications that's really based on the old way in which email used to work. So let me explain a little bit of that scheme now and talk about why it relates to the old way that email used to work. So the core question when you're looking at the Electronic Communications Privacy Act for stored communications, remember when the Electronic Communications Privacy Act for billing information, customer records, right? That's all simple to get with a court order. Stored communications information, the actual content of something like an email, is where we get into this question. So if the information has been stored for less than 180 days, the government must get a warrant with probable cause. And if they have the warrant with probable cause, they can get that stored content from the third party, from the provider. So again, take my phone and my use of Gmail for email. If the government wants the contents of my emails, which Google is housing on its servers, and it's emails that are stored for less than 180 days, it requires a warrant. Now, if the information is stored for more than 180 days, there's a number of different processes that the government could use. The government can use a search warrant, and a search warrant is always a gold standard, except for wiretaps. We've seen that wiretaps require a super warrant, right? But when the government's looking for the contents of stored information, a warrant is always a possibility. But there are couple of other things that are really important. The government can simply get an administrative subpoena or serve an administrative subpoena on notice to the customer. An administrative subpoena is something the government can issue without any court process at all. And the balance here of not requiring court process is this idea of giving the customer prior notice. Obviously, if you give the customer prior notice, that gives them an opportunity to hire a lawyer and contest what you're doing, or protest to the provider, or do something else. Or the government can get something called a Section 2703D order, which refers to the section of the law on delayed notice to the customer. So in this case, the government has to go to a court and get a court order, but the standard, you can see, is well short of probable cause. And again, it is simply that there are reasonable grounds to believe that the contents are relevant and material to an ongoing investigation. That's a much lower showing than probable cause. The government still has to go to a court, but it's even sort of more pro forma than a warrant. And on the back end, if someone is actually indicted and charged with a crime and wants to suppress the evidence, it's harder to show that the order was improperly granted. So why would you use a court order as opposed to an administrative subpoena? Because you can delay the notice. You still do have to give notice to the customer at some point after the order is issued, and there's a statutory framework for that. But you don't have to give notice right away, and that can be a big advantage. Now, why, I mean, it seems a little odd, why this distinction of more or less than 180 days? So part of this has to do with roughly analogizing what the ECPA is doing here with content-based information to a wiretap. So something that's in storage for a shorter period of time is more analogous to still being in transit, which ordinarily would require a wiretap. And something that's in storage for a longer period of time is less like something that's in transit, and it's more like something you've handed over to the third party. So that's part of it, but it also relates, and connecting to that relates to the way email used to work in really the pre-cloud days. So the way email mostly used to work is, you would have your computer. Here's your computer. You'd have an account with your email provider. So we'll just call that P for email provider. And then you would have, the recipient's computer. We'll just say R here, right? So you're sending the email. You would have an email client locally on your local computer, and the emails that you sent would be stored by that client on your local computer. They would be transmitted through your provider, through your host. Actually, we should just really say ISP, right? Your internet service provider, ISP. Transmitted through your host, and your host would store your emails, but only for a limited period of time. Usually it was something like 30 days. So your internet service provider would let you know that after 30 days, it was purging off of its servers the contents of your emails. And if you wanted to keep your emails stored, you needed to make sure that your local email client was storing those emails locally, and then you could use your local email client to archive old emails on a hard drive somewhere. And so part of this limitation is the understanding at the time of the way email worked, and that the content provider is not likely to have emails and other content like that stored for a longer period of time. And if it does, there's some reason about that in the relationship that you have with the provider, and with respect to that kind of content, you probably have less of an interest in it. Now, of course, that's not how email works most of the time today. You have, your local computer, then your ISP is providing you connectivity, and then from your ISP, there's some cloud provider or providers that are providing you the service of an email service. And it might be Gmail, But even if you're using Outlook, as you might, in a workplace, so my law school email is Outlook, Microsoft is hosting all of that in the cloud now. So, and then that's going to the recipient. So the cloud provider is not purging those contents after 30 days. In fact, many of the cloud providers give you unlimited storage, and they don't purge or archive at all. And that's one of the kind of features when cloud-based email first started to become available. That was really attractive. You could move all your archiving out to Google. So really, this limitation, just time limitation, doesn't make that much sense anymore. I mean, there is something to the idea that it's sort of more like in transit if it's a shorter period of time. But 180 days is sort of an arbitrary thing at this point. Nevertheless, that's what the law is, and I think it's fair to say that the ECPA is a place where the law crafted in earlier part of the digital internet era has not really kept up with the way we use the technology now. So let's talk about another piece of this, which is the Carpenter case. The Carpenter case is an extremely important Supreme Court case in this area of Fourth Amendment jurisprudence in the digital age. I teach 2 or 3 different classes, depending on the year, at the law school on cybersecurity law, on privacy, and other things. And we always read Carpenter, and I've had many of my students taking all these different classes will read this case multiple different times, and they also will read it in criminal procedure and in other places. So it's a really important case. So the issue in Carpenter relates to something we were discussing earlier, which is historic cell site data. So remember, our phones are always pinging those cell sites. The provider, Verizon or whoever it is keeping that data, keeping that information, and the government wants to get that information from the provider. Why does the government want that in some cases? Because they want to show your location. I have a colleague at the law school who used to work in the Justice Department, and he tried a case where there were a string of bank robberies throughout New Jersey, and unfortunately a security guard at one of these bank robberies was killed. And the question that the defendants raised was they claimed they weren't present in the location where some of these robberies took place, and there weren't really corroborating witnesses to put them at the location. And my colleague, when he worked for the Justice Department, got this historic cell site data on their phones and was able to show, pretty much precisely the track of the robberies and the alarms and the murder, that the phones were in fact in the locations where those banks are. Now, of course, proving the phone was there doesn't necessarily prove the person was there, but it gets much, much harder to say, well, someone must have stolen my phone, especially if you have other texts and emails and other things on the phone during that period. So that's why this kind of information can be important. And in this case, the question was, does the government need a search warrant? Or can the government simply use an Electronic Communications Privacy Act order, which is a much lower showing, as we've seen, than a search warrant? And the court said, yes, the government does need a search warrant based on probable cause. Now, a little bit of the procedural history. Remember, we always want to, reading a case, we want to look at the issue, we want to look at the holding. To the extent we can, we want to understand the procedural history. So what you have in the part of the case I gave you, the prosecutors had obtained the information through ECPA orders, through Section 2703D. There was a motion to suppress, right? So the defendant says that order was too broad. The court denied the motion to suppress, and then the defendant was convicted of robbery and firearms counts in relation to a number of convenience stores that were robbed. And the cell site information was proving that the defendant was at the locations at the times where the robberies took place. And given the defendant's own criminal history and the stringing together of these different robberies, he got, effectively a life prison sentence. The holding was affirmed by the Sixth Circuit, and then the Supreme Court took certiorari. So as I mentioned, the robberies are taking place at not convenience stores, at some retail locations. Radio Shack's out of business now, but locally in many towns you had a Radio Shack which had cell phones and electronics equipment and things like that. T-Mobile stores, right, had cell phones. Carpenter, the defendant, was arrested along with 4 other people, and the government had obtained a significant amount of this information. So in order to construct this history and to show this defendant's movements, or in a case like this to show a defendant's movements, there's a lot of information. This is part of what you'll see in this case, is that in this digital age, information we have ourselves, like on our phones, or information third parties have about us, has just gotten so much more vast, so much bigger, so much more information is held. And that's one of the complicating factors about this in the digital age. So I want to show you this brief video here to give you a little bit more feel about how this technology works. And this is a video that's on YouTube from a company that is selling some software that helps law enforcement do this. And if you watch it, it's not, the software is not really rocket science. It's basically a spreadsheet type database on the back end that takes all the data in. And by the way, when the government gets this data from the provider, it's usually in a usable data format, like it's comma delimited or tab delimited, so it easily goes into a spreadsheet or a database. And then it's taking a geo mapping program like Google Earth or a similar program like that, and it's mapping it. So let me show you this for a moment. And there's no sound in this video, so you'll just see how it works. So notice how in that example, the data easily comes out in a from the provider in a very usable format. This particular program has a spreadsheet that's set to receive the fields from whatever provider, in that case AT&T. It maps it against the geographical interface, in that case Google Earth, and it shows different ways you can look at it. You can see the exact times. You can even use, as you saw, that really neat sort of time view that shows where a person traveled. Very, very useful for law enforcement. So one of the interesting things about the Supreme Court's opinion in Carpenter is that it really didn't break along the kind of ideological lines you might expect. Because you might sort of tend to think the more conservative justices are more likely in a criminal procedure case to be more favorable to law enforcement, while the more liberal justices are more likely to be favorable to the defendant, to the civil rights of the defendant. And that sometimes is true, but here you really see some ideological divergence. And Justice Roberts, who wrote the majority opinion, is usually considered one of the conservative justices, but does end up holding that a mere 2703D order is not enough for this information, that a search warrant is required. And here's the really core piece of this case. The case does not overrule the third-party doctrine, but it does call the third-party doctrine into question in the digital age in a very broad sense. And in this particular set, right, the specific holding is historic cell site information, and in that context, the third-party doctrine does not apply, and so the Fourth Amendment's unreasonable search and seizure and warrant requirements will apply. Right? So the individual whose cell location information is pinging to the towers being held by the company, effectively the company's holding that information on behalf of the individual. It still is the individual's information under the Fourth Amendment in the way this is looked at. So that specific holding is only this kind of data, but the language, the seismic shifts in digital technology really makes this potentially much broader to other kinds of electronic information that might be subject to disclosure under the third-party doctrine on something short of a warrant. So Justice Kennedy, though, with Justice Thomas and Alito, and here you do see Thomas and Alito are reliably conservative members of the court. Kennedy is, in some cases, is conservative, in some cases has been more progressive. But in this case, the dissenters say the third-party doctrine should apply. The new technology doesn't change the basic premise that if you give up your information to a third party, you've put it out there. It also says, look, this is about a person's movements, which are not really private anyway. They're movements in public. They're, in the example we saw, movements down a public street, or in the case, movements between retail stores that are open to the public, and that's not really private in the home kind of stuff. The data itself is, all it's showing is the person's, location in a general area. There still would be more evidence needed to actually prove that someone committed robberies or robbed banks or committed a murder. And this is a key part of the whole discussion we had last week and this week and next week under U.S. law, and then we'll broaden it out a little bit internationally. The technology is making committing crimes easier, and there's no doubt about that. Digital computing technology and cell phones themselves make it much easier for criminals to coordinate with each other and to commit crimes. So, on the one hand, where the majority opinion sees this kind of lopsided thing, that all of this information about us in a much vaster sense is being held by third parties like cell phone providers. The dissenters say it's really not that lopsided because the criminals are using this technology too, so it's just a kind of balance. So that's the dissenters. Justice Thomas has his own unique slant on a dissent, and it is based on his view of property rights. And so he suggests let's really focus on, when we're talking about search and seizure, whose property is at issue. That's the core question. And he thought that since it's the cell companies' towers that are actually generating the data, and they're the ones who are using that data to manage their networks, that it's their property, and so it doesn't involve Carpenter's rights at all, according to Thomas. Justice Alito adds, sure, maybe there's an issue with how the third-party doctrine is applied in this new digital era, and maybe historic cell site information is one example of that kind of problem. But he says that's the third-party doctrine is a constitutional rule that the court developed out of the principles of the Fourth Amendment, And if the people, through Congress, think there's a specific problem, they can address it. And Congress has done that in the past. It has done that through the wiretap statute. It has done that through the ECPA. It could do that again and craft a new balance. So Alito's view is leave it to Congress. But Justice Gorsuch had a really interesting dissent and very unusual. And he's sort of proving to be, as a conservative originalist justice, a kind of quirky one. He suggests the whole third-party doctrine should be overturned, that the whole thing is misplaced. And taking up Justice Thomas's theme, he takes it even further. He says, the Fourth Amendment is all about property interests. And the question isn't whether some information is given to a third party or not as such. The question is, what's the third party doing and whose property is it? So an analogy would be you park your car in a public parking lot. You are giving a third party possession of your car for some period of time. That doesn't mean that the third party has a property interest in your car. It doesn't mean that the parking garage, has an automatic ability to drive your car wherever they want or to go into the trunk of your car. It doesn't mean any of that. In fact, in the law, it's called a bailment. You're giving your property to someone else to hold for your benefit for a limited purpose and for a limited period of time. And so Gorsuch says, maybe in some cases when we give data to third-party providers like cell providers, we could still say it's the individual's property, but the provider is acting sort of like a bailer, is holding the property kind of like a car being parked in a lot. Maybe in other cases not. His view, we should suss out the whole question that way. So here's our discussion, our question for discussion this week. So the Carpenter opinion suggests that it might be extended to other kinds of technologies. What other technologies do you think the majority opinion could cover or should cover? So it doesn't, for example, talk about our cloud providers holding all of our email, right? So the Electronic Communications Privacy Act with those 180-day windows still applies to email that is held by Google or by Microsoft in the cloud or whoever it might be. Should Carpenter apply to that, for example? Should Carpenter apply to the cell companies holding the transcripts of your texts, which they do have and which they can and sometimes do provide? Or maybe if you find some of the other opinions in Carpenter more persuasive, maybe you agree with Justice Alito that I do think that there are some problems here, like the balance has gotten out of whack a little bit here. But I think the existing constitutional rules that the court has developed over time should stay in place, and then Congress should step in and tweak things. And then, if the technology develops further in different ways, maybe Congress will need to tweak things again, and maybe that's the best way to do it. So which of these opinions do you find most persuasive? Okay, now let's spend a little bit of time talking about the Fifth Amendment. So the Fifth Amendment has a number of provisions that we looked at when we first talked about the Fifth Amendment. Indictment provision, double jeopardy, due process. But the key one we're going to focus on right now is the right against self-incrimination. And so you see how it's worded in here that no one shall be compelled in a criminal case to be a witness against themselves. So when someone pleads the Fifth, right, what they're doing is they're asserting their right to not be a witness against themselves in a criminal case. So for this issue, and the focus of this issue in our kind of cyber discussion is on encryption. So recall our discussion last week about how encryption works, and the distinction I was at least trying to make, whether you agree with it or not, between data at rest or data in motion. So we talked about a general public key encryption scheme, and then we talked about a public key encryption scheme that uses session keys. And these types of encryption schemes are usually used for information that is being communicated. So for an email in transit, for web traffic in transit, for a text in transit, this is the kind of thing we'd usually use. And for me anyway, that raises its own kind of set of issues, and it's really not legally, even technologically possible, nor legally wise to try to require backdoors into this kind of communication. But data at rest, I think anyway, is potentially a different question. And here is where the question, I think, arises, and this can be part of our discussion this week. So this right here is a really simplified heuristic of the way a computer works, the way a personal computer works. So you have a hardware, I've got my mouse here that I'm drawing with, right? You've got your screen, you've got your keyboard, and the like, your motherboard, all the things that go. So you have your hardware. You have a piece of software that is essentially stored in memory on the hardware on your motherboard, which is called the BIOS. So the BIOS, when you're turning your computer on, when it's first booting up, this is the software that's recognizing all the different drives and allowing them to boot. And then on the BIOS, you have an operating system. Most of us are using either Windows or the Apple operating system. Maybe you're using Linux. So the operating system is the basic functionality and components that are allowing the different parts of the hardware on your computer to do what they do and to work together. And they're providing basically hooks for your application programs. So here, I'm using a program called Camtasia to record this video. I used PowerPoint to make the PowerPoint. Right? Those are all application programs, and they work on my Windows machine because they're hooked into the operating system, which then is connecting to the hardware and making everything work. And then we have user-generated content. So this actual video that I am making, the PowerPoint that I've made, is content that I have generated, and that is stored locally on my computer as a file and or in the cloud. In my case, I'm using Google Drive, and so parts of the file are local, parts are in the cloud. And you can think of a computer as this sort of stacked model, right? There are different pieces that really stack on top of each other. So a really simplified notion of a computer. Now, part of the hardware on the computer is going to be some kind of hard drive. That could be an optical drive. It could be a flash drive, something like that. And on that drive, you could have one or more files that are not encrypted. And if you have unencrypted files, so let's say the government has gotten a search warrant from my home computer based on probable cause, and that warrant specifies that I have one or more computers, from which I've been sending certain emails and things that have an IP address. They can seize my computer, they can seize my hard drive, and they can image my hard drive and see the files on my computer. And if they're not encrypted, they will quite easily be able to read those files. And if you've seen it, some of you will know this, some of you haven't seen it, but there are forensic pieces of software that law enforcement uses, and that you can use yourself if you wanted to, that are incredibly powerful and effective at indexing everything on the computer, even files you think you've deleted, and putting together timelines and doing other things like that. You might, on your computer, have one or more files that are encrypted, and this is called file level encryption. So you could simply have certain files encrypted, and if you do that, those files will not be readable. Now, one of the issues with this discussion is we we kind of have in our minds this idea of a a television police drama, and the hard drive goes to the lab, and then the hacker person in the lab hits a few keys, and in hitting those few keys, all of a sudden I've cracked it, right? I've cracked the encryption. It doesn't work that way. Modern encryption is usually 128-bit or 256-bit encryption, and you can't brute force it. So it's simply, if it's an encrypted file using modern 256-bit encryption, that file is going to be unreadable. Now you could have a different method of encryption, and this is really the place where the cases we're going to talk about come up. And it's called full disk encryption, FDE, full disk encryption. So full disk encryption takes advantage of the way the BIOS works usually. So as the computer is booting up and the BIOS is loading, there's a segment that includes a password that then usually seeds an encryption key and a decryption key. So if you put in the right password, and or sometimes if there's a physical key like on a hard drive, and that's present, the drive will boot up, and it will be the whole drive, all the files will be accessible to the person who put in the right password or key. If you don't have the right password or key, all of the files on the entire drive are encrypted and inaccessible, and the drive is basically a brick. This kind of encryption is really cheap, really easy to use, widely available, and simple. So if you have a Windows machine, you have access to Microsoft BitLocker. BitLocker is a 256-bit encryption. You set up a password, and then whatever drive you're specifying, I believe you can also specify it at a folder level. But I do this, for example, with a portable drive that I have in my office at the law school, where I have some work and consulting documents on. So that's encrypted with BitLocker. When the computer boots up, if you want to access that drive, you have to enter the password that seeds the decryption key that then unlocks the files on that drive. And if you don't have that password, you can't get into that drive. Now, in some ways, this is similar to the San Bernardino issue we were looking at last week, because the phone's lock screen, where you have to put in some kind of key, is doing a similar kind of thing with the files on your phone. So the question in these cases that we're talking about here is, if the police seize a drive that has full drive encryption on it, can the police compel the suspect who is in possession of that was in possession of that drive before it was seized to turn over to the police involuntarily the password or physical decryption key or coded decryption key to decrypt the drive? Or is the act of telling the police that password or showing it on a keyboard a testimonial act that would trigger the Fifth Amendment? So like all of these things, there's lots of case law interpreting what the Fifth Amendment means, and one of the core parts of it that relates to our case is something called the compelled production and foregone conclusion doctrine or exception. So the foregone conclusion doctrine or exception applies when authorities know the existence and location of the papers or information that is going to be that is requested to be turned over to the government. And in asking the suspect, the subject of the warrant, to identify the documents in their existence and location and to make them available to the police, is not really revealing any new information. The information itself is already a foregone conclusion. And so, asking a suspect to do something like that under the foregone conclusion doctrine is not an act of testimony. It's an act of production, of turning something over. So the question would be not of testimony, but of surrender of the documents or information. So a number of places, and you can see in this case it involves papers in a tax case, but it's applied broadly in a lot of other contexts. So a defendant can be compelled to give a blood sample, and that's not violative of the Fifth Amendment. So, the suspect putting their arm out and, taking the needle that's going to draw the blood, it is giving the government some information. This is my arm, right? This is my blood because it's coming out of my arm. There's information conveyed there, but it's not considered testimonial. It's a foregone conclusion. Of course, who else's blood would it be? I mean, I suppose there's some, crazy way of spoofing a vein or something like that with fake blood, but, ordinarily, foregone conclusion. So handwriting exemplars, voice exemplars, trying on a piece of clothing to see if it fits, fingerprints, photographic measurements, writing or speaking, the sound of your voice or your handwriting, your stance, standing, your gait, walking, making a certain gesture, that maybe is at issue because someone saw you make it before the crime. All of these things, the Supreme Court has found, are not testimonial. They apply under the foregone conclusion exception, and they're acts of production. They're not acts of testimony. Now, there's one case that complicates this a little bit, and that's U.S. v. Hubbell. And if you recognize that name, it's Webster Hubbell and the Whitewater scandal during the Clinton administration. So the question there was the government, and this was really a pre-computer in many ways case, but the government was asking for huge amounts of documents from Hubbell. And Hubbell's argument was the warrant is so broad, it requires me to organize and identify specific things. And through my act of organizing and identifying specific things, I'm disclosing the contents of my mind. It's as if I'm testifying, yeah, falls into this category, this falls into that category, that falls into that category. And in that case, the court narrowly said the foregone conclusion would not apply. But the most important thing for our purpose is this distinction, which really is dicta in the case, not the rule of the case, but it's language that Justice Stevens used in the case. And he said, it's kind of like telling the combination to a wall safe rather than just holding over a key. So if the government said, you have a locked strong box that we have probable cause to believe contains documents relating to a crime that has occurred or is likely to occur. We have probable cause to believe you have the key to open that box. We require you to turn over the key. According to Justice Stevens, that would be within the foregone conclusion exception. Yes, turning over the key would be giving some information. I have the key in my possession, right? And I'm able to turn it over to you, and it fits this lockbox. That's not testimony. It's just turning over a key. Whereas, according to Justice Stevens, if you were trying to get the suspect or the subject of the warrant to speak or write the combination to a wall safe, then you're getting the contents of the suspect's mind, and that is a testimonial act and not just the handing over of a key. Now, you can question that distinction and the sort of effectiveness of that metaphor, and people have, but that's sort of a divide in some of these cases. All right, now as I have looked at this, and if some other scholars have looked at this, and I asked you to read my article on this question, one of the issues, I think, is what is the nature of testimony? What does it mean to give testimony? And, the privileges against testifying against yourself. And, A couple of scholars have said different things. So some I mentioned in my article. Allen and Mace talk about the cognitive efforts. Pardo talks about the intent of the speaker of conveying knowledge. My proposal deals with something we looked at early in the semester when we talked about internet governance, which is the difference between the sign and the signified, semantic theory. Now, my conclusion, ultimately, as you see in my paper, is that the password that opens up encryption or a decryption key is really not something signified. It's not the truth of something asserted or signified. It's, really more like the key that opens the box. And so I view these cases as not involving testimony and compelling a defendant to turn over that password or that decryption key, not as violating the Fifth Amendment. In fairness, most of my colleagues who write in the cyber law space, and the few that have written on this specific issue, disagree with me on that. And so my article is really, in some ways, it's pushing back against some of the other scholarship in the area, and it's pushing back against some of the cyber civil liberties groups like the Electronic Frontier Foundation, and that's just a disagreement about the meaning of these things. In my paper, I draw some other analogies in areas where we're looking at code, because after all, an encryption algorithm and a decryption algorithm is just code. What the password is doing, which is, if it's a really strong password, it's just random, or more likely it's something, memorable to the user, is giving access to code. And there are other places where the law wrestles with whether code, is really something signified, is really a sign that's really signifying something. So in computer code under the First Amendment, copyright law, and you can look at a little bit of that in the paper. And as I said, my conclusion is that this is not testimonial, and that courts should compel it. I do acknowledge in my paper what I think is really the most broad concern of the cyber civil liberties advocates, which I generally agree with, is that when the government seizes a hard drive or a computer or a phone, the quantities of information that are on that device far exceed anything conceived of to be in any individual's possession when the Fourth and Fifth Amendment were drafted, and even far surpass something like the Hubble case, early 1990s, mid 1990s, kind of just beginning of internet era, but all that was physical boxes of documents. Carpenter's right. The amount and vastness of the information is very different. I think, though, that those are Fourth Amendment concerns. They're about the scope of search warrants, about search and seizure, about the things Carpenter talks about, and that's the proper place to, in my view, to address that. But again, a lot of people disagree with me. So here's some additional questions we'll discuss this week in the forums on this issue. So what do you think about the disclosure of encryption keys or passwords that protect encryption? Do you agree with me or not? You don't have to agree with me. That's fine. A lot of people don't. You can see, by the way, in my paper, a number of courts that have ruled on this. The trend is that most courts that have looked at it have said that this does fall within the foregone conclusion exception, and the government can compel the disclosure of passwords and decryption keys. But there are some cases that say otherwise, and it's not anywhere near having been decided by the Supreme Court yet. And then what do you think about the way I approach it, this approach of sign and signified? Do you find that convincing at all or not? So we have a lot of really good material this week, a lot of good stuff to discuss on the forums. I look forward to seeing you online, and then the following week to picking up some of this discussion in person.